Hello, today date is 22nd July 2026. Today we're having this exam of course 2, contract 2, special contract, second semester, KSLU 3 program. I know you are having the exam, so you need to do the quick recap. Within 15 minutes, I'll just finish it, okay? So that after that you can just revise it. Let us start. See, Dasabarthi Kararo, this is important question, okay? This is important. Define the contract of indemnity and guarantee. See, this is important. It's like insurance company, okay? You are telling someone to do some work. If anything happens, I will be there. Like if you are telling me this is the what indemnity. If you are giving the if you are making the promise means you are the indemnifier. Person who doing the work as per your instruction is the indemnity holder. Okay, that's it. That's nothing else. Section number 134 is very important. Section number 134 is very important. You have to give definition. You have to write 124 is indemnifier, indemnity holder. Nashtabarthi Karaka. Okay, it's very important. Next essential. This is very important. Essential ಬರಲೇಬೇಕು ನೀವು. ನೀವು ಓದಿಲ್ಲ ಅಂದ್ರೆ ತಲೆ ಕೆಡಿಸ್ಕೊಂಡು ಹೋಗಿ ಎಕ್ಸಾಮ್ ಬರೀರಿ. ಇದನ್ನು ಓದೋದಕ್ಕೆ you don't take much tension now. If you're not studied, don't take it much tension. Now exam is there. Just go and write the exam, whatever you know. So essentials you have to write for each question. Loss caused by the human agency. Then these are the essentials. The promise to compensate implied contract, case loss in life insurance. These are case loss. Okay, landmark case law. Adamson versus Jarvis. See, and 200% this case law is important. 200% is very important in problems as it comes. With this case law you do study in this first unit. Okay, very important. Next we'll go to right of indemnity holder. Right of indemnity holder is a things you already studied. Now it is not time for the studying. It is for the revision time. Now contract of guarantee. Guarantee means surety. In the bank, you will give a guarantee, you sign, right? I will become a surety, I will become a guarantor. That is a surety, that is the thing. That's very simple. Section number 124, 126. See, indemnity holder is 124. In the contract of guarantee is 126. Okay, very important, very important. Section number, both are important, both are similar. Only these two sections are important. Okay, and they will ask for the difference also. This is also very important. Here, in this, we will be having one two people. Here will be unclear because A is taking the loan from the B. So you are someone else is coming for giving the guarantee. Right? So three people are there. So that's why three people are there. Agreement is there. This thing is there. So these are differences. Okay, next we go to next question. Define the contract of indemnity. See, these are all the same question. They will ask for the rights and duties. Same question. So same section. Nothing to worry. Same Adamson Jasmine is very important. See, if a very simple, I will explain. Adamson Jarvis case law. If an innocent auctioneer follows the order and gets fined by the real owner, person who gave the wrong order must pay. Today ಏನಾಗಿರುತ್ತೆ ಅಂದ್ರೆ ಎ ಅನ್ನೋ ಬಿ ಅನ್ನೋ ಹೇಳ್ತಾನೆ ಏನೋ ಕೆಲಸ ಮಾಡುವಂತ ಎ ಟೆಲಿಂಗ್ ಬಿ ಟು ಡೂ ಸಮಥಿಂಗ್. ಸೊ ಬಿ ಸೋಲ್ಡ್ ಸಮಥಿಂಗ್ ಬೇಸ್ಡ್ ಆನ್ ದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಫ್ ಎ. ಸೊ ಈ ಸೋಲ್ಡ್ ಸಮಥಿಂಗ್ ಟು Kuri means ship. He sold to C based on the instruction of A because he is like an agent. He doesn't know whether it is stolen or genuine one, correct one. So now we see now the real owner D came and filed the case against B. Now B has all legal rights to get all the compensation from A. That's it. That is the explanation judgment given by the court in Adamson and Jarvis. Okay, that's it. Very important. Okay, next one. So first unit 124 and section 126 surety or guarantee, both are important question. Okay, next guarantee constituents. This is the what is, say, do you agree the contract of guarantee is a tri-party? Yes, it is a tricky question. Same question, but they will ask it tricky way. Three people will be there, right? That's only you have to write the same about guarantee, or don't take it serious. Only three people will be there, like that. Only you write same answer. Nothing else is there. Essential feature of the valid guarantee. These are common sense you have to write. And what is the contract of guarantee? Explain the rights and duties. Okay, the rights and duties they will ask against what is the guarantor though. Guarantor tanala avunge principal debtor and co-surety. Co-surety means for the same loan, three people are giving the guarantee. This person will call it as co-surety. That's it. Saha Katridara anta. ಮೂರು ಜನ ಕೊಡ್ಬೇಕಾದ್ರೆ ಗ್ಯಾರಂಟಿನ ಅದರಲ್ಲಿ ಒಬ್ಬನ ಕೋರ್ಸುರಿಟಿ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಏನೇನು ಅಧಿಕಾರ ಇರ್ತದೆ ಅಂತ ಅಷ್ಟೇ. ಒಬ್ಬ ಮೂರು ಜನದಲ್ಲಿ ಯಾರಿಗೂ ಒಬ್ಬ ಪೇ ಮಾಡಿದ್ದಾನೆ ಅಂದ್ರೆ ಇವನು ಬಾಕಿ ಹತ್ರ ವಸೂಲಿ ಮಾಡ್ಕೋಬಹುದು ಅಂತ. ಸಾಲ ತಗೊಂಡ್ರು ವಸೂಲಿ ಮಾಡಬಹುದು ಅಂತ. ಕಂಟಿನ್ಯೂಯಿಂಗ್ ಗ್ಯಾರಂಟಿ ಮೀನ್ಸ್ ಒಂದು ವರ್ಷದವರೆಗೆ ನಾನು ನಿಂಗೆ ಗ್ಯಾರಂಟಿ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಇವ್ನು ಏನ್ ಹೇಳಿದ್ರು ಕೊಡು, 5,000 ಗ್ಯಾರಂಟಿ ಕೊಡ್ತಾ ಇದ್ದೀನಿ, ಒಂದು ವರ್ಷದವರೆಗೆ ಏನ್ ಬೇಕು ಕೊಡು ಅಂತ ಹೇಳಿದ್ರೆ ಗ್ಯಾರಂಟಿ. ದಿಸ್ ಕಂಟಿನ್ಯೂ ಗ್ಯಾರಂಟಿ ಮೀನ್ಸ್ ಸಿಂಪ್ಲಿ ಪ್ರಾಮಿಸ್ ಟು pay another person loan, but for the series of transaction one after another, promising to pay 50,000 for monthly goods for one full year, like a series of transaction. That is continuing guarantee. Okay, continuing guarantee 129, 124 indemnity definition, 126 for surety. This is continuing guarantee. Very important section. Okay, next we'll go to next question. Bail or bailment. Okay, bail or bailment is very important question. So many sections are there. So if you don't have time, just study this one. 148 is very important. The remaining you can just write the range, like the rights and duties of the bailer, bailee, nikshepa. Bailer means kodonu. Bailer means I will tell you a very simple example. Okay, you are giving your cloth to iron shop, means it is a bailment. Bailment means you are giving some item to someone for the specific purpose, not for you are not selling it. You are not taking any loan from the other person. You are giving it to someone for doing some work like a repair of the cloth or stitching or iron like that. That is a bailor bailment. Very simple. Iron ಮಾಡಕ್ಕೆ ಬಟ್ಟೆ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅದೇನೇ ಬೇಲರ್ ಬೇಲ್ಮೆಂಟ್ ನೀವು ಓನಾಗಿ ಬರ್ಕೊಂಡು ಶಾರ್ಟ್ ಸೆಕ್ಷನ್ ಇಂಪಾರ್ಟೆಂಟ್. ಓಕೆ, ನೆಕ್ಸ್ಟ್ ಪ್ಲೆಜ್ ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 127 is very important. Sorry, 172 is very very important. Okay, bailment 148, pledge is 172. This one now you are taking the loan. See, loan security. Pledge means loan security. Here bailment means you are giving for the repair work, some iron work, ಬಟ್ಟೆ ಐರನ್ ಮಾಡೋದಕ್ಕೆ ಆತರ. ಓಕೆ, ಅಷ್ಟೇ ಡಿಫ್ರೆಂಟ್. ನೋ ನಥಿಂಗ್ ಟು ವರಿ. ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಗಿರ್ವಿ ಇಡೋದು. ಓಕೆ, ಚಿನ್ನ ಗೋಲ್ಡ್ ಯು ವಿಲ್ ಗಿವ್ ರೈಟ್ ಲೈಕ್ ದಟ್. ಗೋಲ್ಡ್ ಪ್ಲೆಜ್. ಓಕೆ, ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್. Right duties, you have to take care properly. You have to take care properly. That's what you have to write. Okay, case law, that Jarvi, Arvind Jarvi, very important. Case law first unit. Then the second unit, I didn't tell. Okay, leave it. You study whatever you want. Define pledge. State the circumstance in which the non-owner make the. See, even the owner only should pledge gold, right? Some thief can't go and pledge your gold, right? See, some of the cases where other person also can pledge. Which are all those cases? That only you have to write. So pledge valid essentials. If you delivery of the item should be there, you have to hand it over to other person. Like say, those things you have to write. Who can pledge? Competent person only can pledge. The real owner only can pledge. Some of the places non-owner also can pledge. Like agent, your agent will be there. I love those people. If there are two owners for the same diamond, one of them can sell, right? Like that. There are many cases of that also you have to write. Then we'll go to define lien. Explain different kinds of lien. What are the rights of the bailee in respect of lien? Lien means nothing but very simple. Lien andre there are two types. Very important charts section. 170, 171. This particular lien means, see, you are given cloth to the iron shop. Okay, if you are not paying the money means you can keep the cloth. That's it. Very simple. Very simple. Till you pay the amount, you will keep the cloth. Okay, that's clear. That is what particular lien. ನಿರ್ದಿಷ್ಟ ಧಾರಣಾಧಿಕಾರ. ಇದ್ರೇನಿರುತ್ತೆ, you this iron shop person can't tell, okay, last month you didn't pay, so I'm going to hold this cloth. You can't do like that. So you can only hold the cloth with you pay which you gave just now. That is what we call particular lien. ನಿರ್ದಿಷ್ಟ ಧಾರಣಾಧಿಕಾರ. In general lien, you can, general lien comes only for the banker, not for everyone. Only bankers, factors, attorney of high courts, these people only can execute this one. See, bank can hold your other property document for the loan which is due now. You have taken the 3 loans, you have cleared these 2 loans. This property document they may refuse to give because this loan you are not cleared. So that is what they can make the lien on all other security which are given specifically for towards the loan. They can't hold your locker items. Locker is different. Whichever only related to loan security they can hold. Okay, the problems will come. Don't get confused. This is the particular, this is the general lien. So difference you have to write. Then we'll go to third unit. In third unit, agent. Agent is very important. Very easy question. Okay, agent means you are telling someone to do work on your behalf. Okay, you don't have time. Okay, that's the agent. You are telling your kid to go and buy the grocery. Means he is whatever he is doing, you will be responsible because he is just acting as an agent. That's it. Agent. Section number 182. Very very important. See, on the your essentials, you can write like this. If you are not able to recall, just write 183 to 185. Essential features of agency, mode of creation of agency, kinds of agency. These are different types of agencies. Next we have to write. Then we will go to the unit 3 is question number 2. Now discuss the contract of agency. Duties. Okay, just rights and duties you can write on your own. So these are all sections you have to write. Then writes the sections. See, if you're not able to remember, just write the range like this. Okay. Next, after agent, we'll go to next one. See, ratification. See, without your permission, someone did some work. Okay. Now later he's coming and informing you, sir, I have done this work. You approve it. Then if he is up, that is what we call it as agency by ratification. So you are approving it, whatever he has done. We have to approve completely. So some of the essential is there that we have to write. Effect of ratification that we have to write. And then we'll go to the next question. How to end the agencies. So revocation by principle, with Ajis Puradu, Muktaya automatic completion, death to these links you have to write. Okay, special rules regarding to termination. So we have to write this one. Then we'll go to third and fifth question. Agency. Delegate is non-protest delegate under the agency, state the exception. See, you are given work to someone. This person can't again give that work to another person. Okay, that is what this question is telling. Still, they can give. See, you are giving contract to some engineer for construction. He will use some other person for the cement work on small work, right? Then that cases they can further take another agency, right? You can further delegate that work to another person. What are the exceptions? Essentials of agency case laws, you have to write. Discuss the maximum. This was you have to write section number 190. So this is not, don't worry about you write. So this here, okay, so this one is very important. Section 182 is very important. Agent principle, all those things you can write. Then this one I have to explain. Rules and regulations I have explained. Then the same question. Then we'll go to fourth unit. In the fourth unit, Point out the various essentials of partnership. Partnership related to partnership. Okay, partnership means four, five, more than two people will be there. See, if he is doing the work, means he is working on behalf of other people. That is what it says. Okay, means whatever profit or loss, everyone should share. That is what partnership. Okay, definition of partnership means section 4. Okay, partnership form is different. Partnership is different. Okay, ಪಾಲುದಾರಿಕೆನೇ ಬೇರೆ, ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆನೇ ಬೇರೆ. ಸಂಸ್ಥೆ ಪಾಲುದಾರಿಕೆ ಅವ್ರಿಗೆ ಏನೊಂದು ಪಾಲುದಾರಿಕೆ ಸಿಗಬೇಕು ಅಂತ. Okay, what are the essentials of partnership? Nature and modes of determining the existence of partnership. This rule is very important. Section number 6. Okay, section number 4 definition. Section number 6 is how to determine the partnership. Okay, exceptions where a profit sharing is not a partnership. Even the profit sharing, it is not a partnership when like that is something you have to write. Then mutual agency should be there. These are all important. Then yes, you have to write. Then we go to define the partnership. Explain the rights of the partners. Explain the rights and duties. You can write your own. You know. Section 4 is very important. Section 5 is important. So rights and duties you have to write. Duties you have to write. Mutual rights and liability between the parties and third party. Okay. Then you have to write case laws. Then we go to third question. Explain the procedure for registration of the firm. Consequences of non-registration. See, you are registered means you will get so many benefits. If you are not registering means there are some disadvantages. What are those disadvantages that you have to write? Okay. ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ನೀವು ಬೇರೆ ಕೇಸ್ ಹಾಕ್ಬೋದು. ಇಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ಬೋದು, ನೀವು ಬೇರೆ ಕೇಸ್ ಹಾಕೋದಕ್ಕಾಗಲ್ಲ. ಸೊ ಅದೇ ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ the procedure for registration you have to write. If they ask very important question. So already important question already shared. So just I informed. See, whatever you already studied, that much only you study now. Now exam is there. Change the forms. Changes in forms. If there is a changes, you have to inform to the register. Okay. Consequences. No suit between the partners and firm. They can't file. No suit against the third party. They can't file. No claim of set off. Third parties can sue the firm. Other person can sue. These person can't sue if they have not registered a firm. Okay, exception to the rules. So some of the exceptions are there. Even though the firm is not registered, still they can file. Which are those exceptions that you have to write? Like partners can beg the court for the complete dissolution. ವಿಸರ್ಜನೆ ಮಾಡ್ಬಿಡಿ ಸರ್ ಅಂತ ಕೇಳ್ಬೋದು. ಫಾರ್ಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದ್ದು ಅಲ್ಲಿ ಪೆನಾಲ್ಟಿ ಫಾರ್ ಫಾಲ್ಸ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟರೆ ಆ ಥರ ಆಗುತ್ತೆ. ಓಕೆ, ನೆಕ್ಸ್ಟ್ ಡಿಸಲ್ಯೂಷನ್ ಆಫ್ ಇದೆಲ್ಲ ವಿಸರ್ಜನೆ ಆಗ್ಬಿಡೋದು. ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫಾರ್ಮ್ ನ ಹೆಂಗೆ ಮುಚ್ಚಾಕೋದು ಅಂತ. ಸೆಕ್ಷನ್ ನಂಬರ್ 39 very section number 39 is very important. What are different ways? Dissolution by agreement and compulsory. If the court is telling compulsory close it. Yeah, some if person dies and these are all different types. Grounds by the court. See, this question they will ask. See, this is a normal cases. Okay, sometimes they will ask by court. What are the grounds of the dissolution by the court? What are the based on which are the ಯಾವ basis ಮೇಲೆ court ಕಂಪನಿನ ಮುಚ್ಚಾಕಿ ಅಂತ ಹೇಳುತ್ತೆ ಅಂತ. Unsound mind. If a partner goes completely insane, court closes the firm because the madman can't make safe business decision. So that is the reason. Permanent incapability. These are all things they will ask. They will ask question like it also. State the rules regarding the settlement of the account after dissolution. So this one they will not ask, but if they want to make the question part of, they will ask. Okay. Then we will go to the admission, retirement. This one they will not ask. They will ask only for 8 marks. What is the short notes they will ask. Okay. We will go to 5th unit. Define the contract. State the distinction between the contract of sale. This is a very easy question. See, during the marriage, you will make first you will do engagement, then you will go for the marriage, right? Like a ring exchange, then you will do the marriage, right? Similar to in the sale also. First you will do agreement. So I will purchase like some 5 rupees advance you will pay, remaining amount will pay like that, right? After that you will purchase, right? So this part is what we call as agreement to sale. Agreement to sell. Okay, agreement to sell. ಮಾರಾಟದ ಒಪ್ಪಂದ ಮಾಡ್ಕೊಳ್ಳೋದು. ಇನ್ನೊಂದು, see, they directly selling to someone without waiting period. That is what we call the direct sale. Sale of goods. These are all movable items. Okay, is strictly for foundation for every small and big shop transaction. Contract. See, section number 4+1 is important. It's clear legal deal where the seller initiated transfer or promises to transfer full ownership of an item to a buyer for pure money. It's very important question. These are all two people should be there, goods should be there, transfer should be there, price should be there. These are all important. Then sale and agreement to sell. Sale means direct selling. So you are going and purchasing, it is coming. That's sale. Agreement to sell. See, you are telling I will buy later. The waiting period contract where the ownership will magically shift only on the future date. Okay, distinguish. You have to write the distinction. Next, unit 5, second question. Who is the unpaid seller? See, you are the seller. Okay, someone came and asked for some items, and so you are given him, but he is telling I will give after 1 hour. So now you are become a unpaid seller. ನೀವು ಯಾರೋ ಬಂದ ನಿಮ್ಮ ಹತ್ರ ಏನೋ ಕೇಳ್ದ, ಚಾಕ್ಲೇಟ್ ಕೊಡು ಅಂತ. ನೀವು ಚಾಕ್ಲೇಟ್ ಕೊಟ್ಟರೆ ಅವನು ಅಮೌಂಟ್ ಆಮೇಲೆ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾನೆ. ಸೊ ನೀವು ಕೊಡೋರಿಗೆ ನಿಮ್ಮನ್ನು ಏನಂತೀವಿ? ಬೆಲೆ ಸಂದಾಯವಾದ ಮಾರಾಟಗಾರ. ಮಾರಾಟ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ನಿಮಗೆ ದುಡ್ಡು ಬಂದಿಲ್ಲ ಅಷ್ಟೇ. ಸೊ section number 45. So this is a different act, sale of goods act. So second question. Then we'll go to third question. ಕೊಳ್ಳುವವನೇ ಎಚ್ಚರಾಗಿರಿ. So person who buy the item, you should be careful. Caveat emptor. In this caveat emptor, you explain the doctrine of caveat emptor. State the exception to it. ಕೊಳ್ಳುವವನೇ ಎಚ್ಚರ. ಯಾವಾಗ ಕೊಳ್ಳುವವನೇ ಎಚ್ಚರ ಆಗದೇ ಇದ್ರೂ ಕೂಡ ಅವನಿಗೆ ಸೇಫ್ ಗಾರ್ಡ್ ಸಿಗುತ್ತೆ. ಮೊದಲಿಗೆ ಗೊತ್ತಾ, ನೀವು ಹೋದ್ರೆ ಏನೋ ತಗೊಂಡ್ರೆ, ಯು ಟೇಕನ್ ಸಮಥಿಂಗ್. ಸೊ ಅರ್ಲಿಯರ್ ದೇ ವರ್ ಟೆಲ್ಲಿಂಗ್ after you purchased, they will not take any responsibility, because while taking only you should verify everything like that. That is the concept. In Bengaluru, we will see, right, in the footpath they will sell Now with no guarantee, no warranty. You take it. That was the earlier definition, earlier doctrine. Now it has changed. Some of the exceptions also added. The meaning of exceptions, those things you have to write. The exceptions. See, he is telling you to give water bottle means for filling the hot water means you should give good one. After putting hot water, if it breaks means so seller is responsible because it is implied. There's a implied condition. I need a hot water bottle means it should be good one. Those are all exceptions. In this case, the buyer no need to be extremely careful. Your seller also will be held responsible. Okay. Next fourth question. No one can transfer. See, your vehicle. Okay, your vehicle. If you transfer, it will become a correct transfer. If some thief is selling your vehicle, it is not a correct transfer. Right? He will not get the correct rights. That's what this question. That's it. Nothing else. Then what is this definition of warranty? This question is very very important. But this is a condition. This is a warranty. Warranty means this is a condition. Means also condition means you are asking a new car. Means you should give new car only. Okay. Warranty means he is giving 5-year warranty. Okay. Sometimes if it is not coming 4-year only, it's coming remaining amount. He will give some compensation. He will do the repair. That is what it is. Condition is if you are asking for a new car, you should give new car only. If he is telling second-hand car as a brand new car, then condition is failed. So even though you have used 2-3 years, so that used car. After you got to know this is a used car, you can return back to the seller. Seller can't tell you have used 2 years, so I will not going to give money. I will give offer 50%. They can't tell. You can cancel the contract. You can get the full amount. Okay, that is what this question. Very very important. Very easy question. Okay, don't worry. This section you have to write 12 class 2 condition, 12 class 3 warranty difference. This is very very important. They may ask this question. At least they will ask for 8 questions like that. Also they will ask implied. This all you can write the range like this. 14 to 70 if you are not able to remember. Okay, what is the last question? ಮಾರಾಟ ಮತ್ತು ಮಾರಾಟ ಕೊಳ್ಳುವವನಿಗೆ ಮಾರಾಟಗಾರನ ಉಲ್ಲಂಘನೆ. What are the remedies available to the seller and buyer for the breach of contract? If there is a breach of contract, then what are the remedies available? ಒಂದು ಕರಾರು ಮಾಡ್ಕೊತೀರಾ ಅದು ಕರಾರು ಪ್ರಕಾರ ನಡ್ಕೊಳ್ಳಿದ್ರೆ ಏನೇನು ಪರಿಹಾರ ಸಿಗ್ತದೆ? These are all common sense examples, but sections are there. If you are not able to remember sections, just write on your own because it's exam time. Exam is there today. Okay, all the best. Bye. I'm going to close it. So some of the case laws are there. You study. This is very important. And leave with the box handle. This case law is important. So at least study one case law per unit, one case law for topic. So you will get good marks. Chances of getting passing marks will become high. So just spend something. See, if you are not able to remember Adamson Jarvis, at least write as per the Adamson case law. Otherwise, write as per the supplemental judgment. Otherwise, you write A and B. A sold the item to B. B sold the same. Like that, you can just write the example. Okay. All the best for your exam. Okay. Problems also explained. Don't worry. You write it. All of you will get the good marks. All the best. Bye bye. Don't get tension. Okay. All of you are going to become an advocates. Okay. You should be very strong. You are going to be the boss in the exam hall. Don't get scared. Don't get worried too much. You can have a chocolate, okay, coffee chocolate. So it will reduce your tension. Bye. Thank you. Second semester KSLU 3 LB program. See, these are the questions we already provided to all of IQCourt Law Academy students. Now we don't have time to go through all this, so we have also provided the summary of the problems along with the answers on sections. So let us directly jump into the summary of the problems. You have to write like this. This is the question. You have to write the explanation of this question. Then again, examine. You have to examine the legal principles relevant to this case. Then final judgment and justification. On what basis the judgment you are giving or suggestions you are giving. Sometimes they will ask for the suggestion. Sometimes they will ask for the likely judgment. All those things you need to write along with the sections. And case laws you have to write. And then you can write example along with the section and analogy also you can write. How that example is relevant to this. Like this, we all explained everything. Now let us jump into the summary. Okay, this is summary nature of question. So nature of the policy, liability of the adult who stands as the guarantor for the minor. Okay, he is responsible. That's it. So section number 138, very important. It says surety liability. Okay, minor is legally incapable of making the valid agreement. If the competent adult guarantees a loan taken by minor, the adult steps into the shoes of the borrower, takes full primary responsibility. Very very important question. Okay, we'll go to next question. Question about remedies available to the owner when neighbor given custody of a cow for a month unauthorizedly sells the cow to a ಥರ್ಡ್ ಪಾರ್ಟಿ ಆಫ್ಟರ್ 50 days. ನೀವು ಯಾರು ಕೊಟ್ಟಿದ್ದೀರಾ ಕೌನ ನೋಡ್ಕೊಳ್ಳಿ ಹಸು ನೋಡ್ಕೊಳ್ಳಿ ಅಂತ ಅವರು ಇನ್ನೊಬ್ಬಂಗೆ ಸೆಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. ಸೊ ಏನಾಗುತ್ತೆ? ಸೊ here you have to take bailer and bailment will come into picture. So liability for the unauthorized use, termination of bailment. Doing an unauthorized act allows the actual owner to terminate the contract. Caretaker is liable to pay the full compensation. Okay, next question. Whether true owner can recover the lost ring from an innocent buyer who purchased it from the original finder. So here section 169 says about sales sale by finder of goods. Section 71 says responsibility of finder of goods. A person who finds a goods must protect them like a responsible caretaker. Then if a owner is not found after reasonable effort, the finder has the legal authority to sell the goods. So it has in detailed explanation conditions. That much time we don't have. So this much if you write, you will get some marks. Okay. This is a summary. We are not elaborating. Still you should get some marks, right? That is the reason. I'm just explaining the brief. ಸಿ ಯಾವುದೋ ಐಟಮ್ ಕಳೆದೋಗಿರುತ್ತೆ, ಅವನ ಹತ್ರ ಅವ್ನು ಬೇರೆ ಹತ್ರ ಪರ್ಚೇಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾನೆ. ಸಿ ನಿಮ್ದು ಐಟಮ್ ಕಳೆದೋಗಿದೆ, ಅವನು ಯಾರಿಗೂ ಸಿಕ್ತು, ಅವನಿಂದ ಬಂದು ಸೇಲ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾನೆ. ಸೇಲ್ ಮಾಡೋ ಕಂಡೀಷನ್ಸ್ ಇದೆ, ಅದೆಲ್ಲ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಕ್ಕೆ ಹೋಗ್ತಿಲ್ಲ ನನಗೆ. ಈಗ ಇವನ್ಗೆ ಸ್ವಲ್ಪ ಸಿಕ್ಕಿರೋ ಐಟಮ್ ಇಟ್ಕೊಂಡಿರೋ ಅವ್ನು ಬೇರೆ ಸೇಲ್ ಮಾಡಿದ್ದಾನೆ. ಇವನಾಗ್ಬಿಟ್ಟು ಇವನ ಹತ್ರ ಇಸ್ಕೋಬೋದಾ? ಇಸ್ಕೊಳ್ಳೋಕ್ಕಾಗಲ್ಲ ಸಡನ್ ಆಗಿ. ಸೊ ಸರ್ಟನ್ ಕಂಡೀಷನ್ಸ್ ಇದೆ. 2/3 ಅಷ್ಟು ಖರ್ಚು ಜಾಸ್ತಿನೇ ಆಗಿದ್ರೆ ಅದಕ್ಕಿಂತ ಆ ಟೈಮಲ್ಲೆಲ್ಲ ಸೇಲ್ ಮಾಡಬಹುದು. ಕ್ವಶನ್ ರಿಗಾರ್ಡಿಂಗ್ an agent who sells the cattle on principal's instruction in good faith gets sued by the true owner and claims the compensation from the principal. This one is section 125. Right of the indemnity holder. This is the first unit. Agent right to be indemnified. This is a question. Principal must compensate an agent for any losses suffered by executing the lawful instruction. See, this is the first unit. I already told you, this is the sections are important. See, in this one now, Swan and Bank Jarvis is important. First unit, Jarvis is important. Case law Jarvis. See, Adamson and Jarvis important. In the then second unit, many other cases also important. I just showing you the case laws. Then Swan and the Bank of Scotland also important. Chikkava Pannamma Tammaya also important. Section 145. Then these case laws also important. State Bank of India, C.R. Raju case laws. And this is related to the Girvi. Phillips versus Brooks. This is very important case law. So this case law also already given in the blocks materials. Then Phillips and Brooks, it is related to the pledge. Okay. Then we'll go to next question. Agency. And also Adamson and Jarvis also you can write for this also. And another case law, so you can write for agency or Lilly versus Doubleday. This is case law is very important. Lilly versus Doubleday case law. Adamson and Jarvis, same case law. First unit case law also you can write for the agencies. Very, very important case law. Okay. Then this is third unit. Okay, we'll go to fourth unit, one case law. See, Crocs versus Ekman. This case law is important. This is for the fourth unit. Okay. Fourth unit related to the partnership. Okay. You can write any other case laws as per your wish. This is also important. Gupudal Govardhan Das versus Chunilal Sam Lal. You can take another case law. Some don't have time. So this one fine. Then go to fifth unit. There are many case laws are there. This one Priest and last is very important case law. Priest and last. Hot water bottle case. Okay. Then Priest versus ice. This okay. That one case law is very important. The remaining also important. You have to study. Now don't take much risk. Okay. Study what you are studying right now. Just revise it. Okay. Handley versus Bax Handley. This is also very important case law related to the remedies available to the seller and buyer. Okay. Thank you.